Hello, and welcome to the Shine More podcast, where we are shining a light on all things special education with a passion to help those with special needs and a mission to empower individuals with various abilities. Today, we will be discussing guardianship and guardianship advocate. To help us shine a light on this topic is Amber R. Donnelly, who is a licensed attorney, and she has been so for about 14 years now. She also owns her own law firm in Orange Park, Florida, called Donnelly Law Firm. Thank you so much for joining us today.
You are very welcome. I appreciate the invitation.
Yes, so let's just get right into this conversation. So please explain to us, what is the difference between guardianship and guardianship advocate?
And that's a very great question because there are times when families come in requesting a guardianship when they really need a guardian advocate. The biggest difference is when we're dealing with a guardianship, it's a loved one or a family member seeking to take care of a person who is now incapacitated. And when we're thinking incapacity, what should come to mind? Someone develops dementia, someone has a stroke, someone's on a ventilator. But at the end of the day, at some point they had capacity and now they don't. And the loved ones need to step in and take care of them. And then another guardianship is a guardian for minors. So if there is someone under the age of 18 and maybe their parents have passed away and someone needs to step in and take care of them, or they've inherited over $15,000, a guardianship is needed in those cases.
Okay. Okay, and when it comes to individuals with special needs, more so, they were born with a disability. Say, for instance, individuals with autism, various intellectual disabilities. How could a parent go about gaining guardianship or a guardianship advocate for those individuals?
For individuals that have developmental disabilities, we're in the land of guardian advocate. Okay. There's a history that they have a developmental disability, which can include autism, cerebral palsy, Down syndrome, spina bifida, or other intellectual disabilities. And what has to take place with the guardian advocate, the loved ones would have to provide a letter from a doctor that includes the diagnosis, or an evaluation, from a psychiatrist that identifies the diagnosis. One distinction between a guardianship and a guardian advocate: guardians are required to have an attorney represent them in the process. Okay. Guardian advocates are not required to have an attorney. And if they're savvy enough to figure out the paperwork they need to complete and appear on their behalf at a hearing, they're more than welcome to do that. But in terms of the process, it's a petition for guardian advocate that's filed in the circuit court wherever you live in the state of Florida. It's providing a background check, a credit report, and the requirements for a guardian or guardian advocate is that those individuals have to be 18 years or older. They have to be competent, and they cannot be convicted felons. And it's the judge who appoints the guardian or the guardian advocate. And in the process, the guardian or guardian advocate has to complete an application along with their petition that the judge will review when vetting whether or not the person's a good fit to care for someone else or someone else's property.
Okay. And when should a loved one, family member, parent start looking into this process?
I would say it's important when your child turns 17, possibly 16, if you're a planner like me, so you can start getting your affairs in order. But the statute says a loved one can apply for guardian advocate when the person is 17 years old and 6 months. Okay. And so I'm a planner. So if I had a child with special needs and I know I needed to continue to make decisions for them regarding their education, regarding a vocational rehab, regarding medical decisions, I'm thinking in advance, probably at age 16, to at least get the proper information, identify whether I want to represent myself or hire an attorney, and start getting the paperwork in order with the help of an attorney or in my individual capacity. And the other thing to consider is you're going through the court process, and it is a process. So it's not overnight that you can become your child's guardian advocate. So plan in advance. I have people that come to me the month before their child turns 18. The guardian advocate's not going to be in place by the time the child turns 18. So at a minimum, when your child's 17 years old and in 6 months, start planning. So hopefully the guardian advocate's in place by the time they're 18, and there won't be a break in your authority to be able to manage their affairs or to take care of them.
Okay. Now, you mentioned educational purposes. I know as working in the field of education, especially with individuals who are ages 18 to 22, they're still in school. I know that if a parent does not have guardianship, that means that individual is their own person. They are supposed to, in a sense, make their own decisions, which for some parents, that doesn't seem like that was to be something that their child can do, but that's their legal right. So when it comes to that, if the parent does not have guardianship and they still want to attend those meetings, or medically something happens and things like that, what do you tell your clients if you know they're kind of slow with the process? Because I know sometimes they don't get it, and some people just say, hey, that's my child. What do you mean I can't be at this meeting? What do you mean I can't make the decision regarding their medical decisions at this time? What advice do you have for them to when it comes to just preparing them for that and helping them to realize the importance of getting that guardianship?
It is so important to get the guardian advocate in advance, because the reality is, even though your child or loved one may have a developmental disability, once they turn 18 years old, they are legally an adult and are able to make decisions on their behalf, do whatever they want to do. Remember when you were 18? And the rub in this situation is, for some people with special needs, depending on where they are on the spectrum, they don't have the capacity to make those decisions or determine where they live, or to sit in on an IEP meeting to make decisions about their accommodations or talk to the doctor about their health care. And that's why it's vitally important for parents and loved ones to plan in advance. And I hear it all the time, well, this is my child. That is correct. But in the eyes of the law,
right,
when your child turns 18, they're an adult and they're free to make decisions. And the parent has no legal authority to make decisions. The good thing that I've seen is that if a parent has been actively involved throughout their child's life, and they have a relationship with the doctor or have a relationship with the educators, they're typically willing to work with the parent and still give them information. I won't discuss whether or not that's legal or should be done.
Right.
But I will say, practically speaking, everybody at the table is wanting to do what's in the best interest of that now adult who has developmental disabilities. But don't become frustrated if you run into someone who says you don't have legal authority, because the reality is, if you're not the guardian advocate, when your child turns 18, you're not. You don't have the authority.
Right, right. How often, once a family member, loved one gets guardianship or guardianship advocate, how often do they have to renew? Is this something they have to do every year, or how does that work?
The guardianship or guardian advocate is in place until a petition for discharge is filed with the court and the judge discharges the guardian.
Okay.
In situations where I've seen guardianship cases closed out or the guardian discharge, let's say under a guardian, the person that had an incapacity is now capacitated. Maybe they were on a ventilator. There was a miracle. They came through and are able to manage their own affairs. So under a guardianship, you can petition the court to restore the rights to the ward, they're called, and if they now have capacity. With guardian advocate, it's not as common for someone with an intellectual disability to get to the point where they can take care of themselves, absent a miracle, which is still possible. And so typically I see these guardianships or guardian advocates in place until the ward passes away.
Okay.
And there are requirements once the court appoints the guardian or guardian advocate. It's also important to know that the court will appoint an attorney for the person who who may need a guardian or a guardian advocate to make sure their best interest is being served. And at the hearing where the judge determines whether or not the guardian or guardian advocate is appointed, the attorney for that person is providing their case and whether or not the guardian or guardian advocate that's proposed is fit. And the other thing to note is it's essentially a job. When you become a guardian or a guardian advocate, you're required to do an initial plan and inventory. Once you're appointed, you're required to do an annual plan or annual accounting if you're managing funds for someone. And it's on an annual basis and typically in place until someone's requested that it be closed out or unless someone passes away.
Okay. Thank you so much for that wealth of knowledge. I think that that's information that parents need, that they need to start thinking about, like you said, once their child starts getting close to the age of 17, and just the importance of it. I did want to also ask you, I've heard that sometimes depending on which one you get, sometimes some people look into getting the guardianship or guardianship advocate. I don't want to say it incorrectly, but where say they still have the right, that individual still has the right to say vote or still have the right, like what's the difference in that and which one does that fall under?
So for both the guardianship and guardian advocate, the court is taking away certain rights from the ward.
Okay.
The guardian or guardian advocate may be able to exercise some of the rights for the ward depending on what the right is. So for example, the right to vote. If the ward has the ability to vote and make a decision about who they want to be the president or elected official, the court will grant that right to the ward. And interesting enough, I have a case where my clients are the parents of an individual with autism, and the only right he has is the right to vote. He's heavily involved in politics. He's high on the spectrum when it comes to autism, but needs additional support. So he has the right to vote. But other rights can include determining where you live, having a driver's license, managing your assets, making healthcare decisions, the right to travel, the right to marry, the right to enter contracts, the right to work. And so some of those rights that can be delegated to the guardian or guardian advocate would be the right to determine where you live, to manage your assets, to determine to travel, to enter contracts. But the rights that are not able to be delegated, the right to vote, the right to marry, and in the process of applying for a guardian or guardian advocate, you, as the person requesting it, would determine what rights your loved one can exercise and what rights you want taken away from them. And then the judge makes the final decisions. But in both a guardian and a guardian advocate, rights are taken away from the loved one.
And what is there anything that is included in the guardianship or guardian advocate when it comes to if something happens to the guardian? You know, you never want to think about these things most times in families, but say for instance, you know, there's an issue that happens with that family member. Now the family member who was the guardian is no longer able to fulfill, you know, his or her role as that guardian over that person. Is there is there something where a family member can have something in place? Is that a part of the process, or is that only if that family member, you know, seeks to have someone, like say if something happens to the mom, the dad is the next person, or say another family member? Is that something that a parent would have to say, or is there a way to kind of automatically have that in place?
I will say when I'm working with parents of an adult child or soon to be adult child with a developmental disability, my recommendation is to have the parents be co-guardian advocates.
Okay.
So they're both the guardian advocate at the same time. But it's critical that those co-guardian advocates communicate effectively, they work well together, and put their child's best interest at the forefront of the decisions that are made. If there's a breakdown in communication, it could be bad for the loved one who is in need of a guardian advocate. But in instances where there's only one guardian advocate, you can request that there be a successor guardian or successor guardian advocate, but that person will have to go through the same process where they have to apply to the court. A petition for successor guardian has to be filed. And if for some reason the guardian or guardian advocate is, if they're unable to continue in their role for any reason, the court is at least aware that we have somebody waiting who's on deck. But the process is still the same. The statute says they have to provide a credit report, do a background check, and those same requirements apply. And it's the court that would put that successor guardian in place and give them the authority to start acting. So my practice typically, most times when I'm meeting with people, they're just overwhelmed with the process of becoming the guardian or guardian advocate. So that's the focus typically when people come to me. Let's just get you appointed. Let's get you in place. Let's do the initial reporting. And then that next year, let's start talking about who's on deck if you can't continue to serve in this role. And that's an important conversation because things can happen where the guardian can't continue to serve, and you want to make sure people are aware of the fact that they're an alternate or the backup.
Yes, yes. Okay. Thank you so much for sharing this information with us. Is there anything else you would like to add? Anything that you think would be important to share?
So I know we spoke briefly yesterday and you mentioned the power of attorney. So since we have some time, I at least want to mention that. Typically, the power of attorney or a durable power of attorney is put in place when the person who wants to give the power to someone has the capacity to do so. So typically, when we're dealing with someone who may have a developmental disability, depending on where they are on the spectrum, they may not be able to say, oh, let me talk to an attorney because I want to give you power under a durable power of attorney to manage me or to manage my assets or to make decisions regarding my health care. So in the cases that I have, it's not commonplace for the board to be able to make a decision and to be able to sign off on a durable power of attorney. Under the example of a guardianship, when people have capacity and then they become incapacitated, while they have capacity, they can designate who they want to make decisions for them regarding finances or healthcare decisions. And if that is in place, and they become incapacitated, the durable power of attorney is still in place. The healthcare surrogate, where you've identified who makes your healthcare decision, is still in place. But I typically don't see a durable power of attorney or healthcare surrogate with the clients that I represent for guardian advocates because their children or adult children don't have the capacity to have the conversation about, I want my parents to be my agent under a durable power of attorney.
Okay. Thank you so much for clearing up the differences in all of those areas, which is so important. I hear a lot of parents asking the questions and they, you know, wish they can have the information. And I know sometimes it also varies in cost when you're looking at attorney fees and all of that. I know that there are some areas that will do it pro bono. I know there are different agencies that will kind of help out with that. When it comes to in the state of Florida, is there kind of a price range typically for the court fees and all of that? I know legal fees are different, but when it comes to filing the court fees and things like that for guardianship, guardian advocate, is there kind of a range? Because I know a lot of parents sometimes they ask those questions.
So it would be important for folks to go to the clerk of court for their particular county to determine what the fees are. But I will tell you, with the guardianship, you have two set of fees because you're determining incapacity. So there's a mental health case, and then you're determining the appointment of a guardian. So then there's a guardianship case. With a guardian advocate, there's only the filing fee for the guardian advocate, and it's a few $100s.
Okay.
The other thing I want you to know is if the person you're wanting to take care of is indigent, they can't afford it, you can file what's called an application of civil indigent status.
Okay.
Civil indigency. So typically my clients who pay me and I'm representing typically the parents, they can afford to pay me, but their soon to be adult child may only be getting, SSI or they don't have any income at all. So you can complete the application for civil indigency or indigent status where you list the income and assets of the person who needs the guardian advocate and file that with your case. The clerk of court will review that application and determine if the person is indigent, just meaning they can't afford to pay the filing fees and the court-appointed attorney. If the clerk determines the person is indigent, they will waive the filing fees.
Okay.
They will waive the fees that go to the court-appointed attorney and find another funds from the government to be able to pay them. And then for guardianship with the incapacity piece, there is an examining committee of 3 medical professionals that are appointed. It would waive the fees for those 3 medical professionals, and they'll be paid from some state fund. And so that's important for people to know. It's not based on your income as the parent or your assets as the parent. It's based on the person's income or assets that you're attempting to take care of. Okay. And that's a great way to be able to get those fees waived. So with all of my guardianship and guardian, well, not all of them, because in my guardianship cases, those folks may have money that need to be protected, so they wouldn't qualify. But in all of my guardian advocate cases, I'm always filing an application for indigent status for the clerk to determine whether or not those additional filing fees, attorney's fees for the other attorney appointed are waived. And generally they are, because the ward typically doesn't have any assets.
Right. Thank you so much for that. That's something I never heard of. So that is great information. I hope that we have been able to shed a light on this topic. I hope that you are coming away from this with more information. If you have any other questions, please type it in the comments. You can send me an email and we will try to help guide you or to get you to the right person if we can. Thank you so much, Mrs. Donnelly, for joining us. I appreciate you. Thanks so much for sharing your time, your expertise. We appreciate you. And thank you so much for joining us on our podcast today. See you soon.